Next, we have Kent Whiteman from the Family Law Section, wishes to speak and opposes the bill. You have 2 minutes. I'm sorry. Kent. You've been testified before with us, haven't you?
Yes, on other matters.
On child welfare with the military. Did you come forward on that?
Yes.
Yes. Thank you for coming back.
I represent the Family Law Section of the State Bar. It's a group of about a little over 2,500 lawyers who represent both fathers and mothers in family disputes. We oppose this bill. This bill, and I think you should look at what the bill does because I don't think it's been represented accurately. It mandates as close to equal physical custody in every disputed case. That's mandated, unless there is clear and convincing evidence of one parent's unfitness. You can't even begin to discuss best interests of the children or anything about the children unless one parent is shown to be unfit by clear and convincing evidence. That's the standard. That's the monster parent. Unfitness is where you terminate parents' rights, where you remove a child from a household because a parent is that bad. That's the standard set up here for you to even look at the children at all. Other than that, and I think the chair's right, this is a parent's rights bill. These children are now objects. They're like property. You divide them 50-50 in every case. If a child is despondent, if a child is suicidal, if the child is showing obvious distress, not going to school, something like that, the judge would have to say in that case, I'm sorry, that's irrelevant. How the child is doing under this situation is absolutely irrelevant because this is a parent's right bill. The child is like property. You don't even look at the child under this bill. It also mandates one solution for all Michigan families in these contested cases. That right now, Michigan families come to all kinds of different arrangements based on what's going on in that family. This says the government knows better. We are going to mandate one solution exactly or as close to exactly equal physical custody as we can get for all Michigan families because it's all cookie cutter. That's what it is. That's not a good idea. Families in Michigan are all different. In some cases, parents do substantially co-parent. They do that during the marriage. They do that after the marriage. And that's what they tend to agree to, and that's what comes out. In many Michigan families, they've divided it differently. One parent may be primary wage earner, the other one is primary caretaker. That's what they've done during their marriage. That's what they do after their marriage. This says, it's going to be one solution for everybody. And that, I think, is unfortunate. Currently, 95% or more of cases settle. There's less than 5% that actually have to go to court and litigate. Most families are able to reach agreement. What they're told to do is look out for their children. Negotiate according to what's best for your children. 95% of couples are able to do that. This will create litigation because it says, if you can't reach an agreement, the court will not look at the best interests of your children. You have an absolute right to 50%, unless you're unfit. So not only will it create litigation because it forces you into something that most people aren't doing. I mediate cases for a living. Very few couples working out what's best for their kids agree to exactly equal custody. Real common, something like 1/3, 2/3 is real common. Most people agree to joint custody, both joint physical custody and joint legal custody. I rarely see a case that isn't joint legal and physical custody. It's the outlying cases, the fringe cases, where that won't work for the families. That's what people are doing now. Are they doing exactly equal custody? Only in really rare cases. And so this bill is saying, government knows better. You families don't know what you're doing. We're going to force you to do what we think, according to this new social theory that actually isn't really backed up by the data, but we're going to make you do this. And for a parent who isn't able to reach agreement, they can always say, hey, if I go to court, I will get 50%. And what kind of litigation will you get now? Not litigation that says, look what's best for the children. It's litigation that's going to be attacked on each parent because you have to prove unfitness. That's not talking about the kids. It's talking about a parent is unfit. You have to attack the other parent. Is this what we want? Is this the kind of case we want? Each parent coming into court and attacking each other to try and win the children, instead of what we have now, which is parents trying to figure out what's best for their children. And everyone's talking about... Thank you for your politeness. So right now, what people are saying is...
Okay, Ken, if you can conclude, because I'm going to ask you because you wanted the state to you were in favor of the state making the decisions in that military custody battle. You were the exact opposite, where you thought the state knew best. So I'm a little bit perplexed at your testimony this time.
Yeah, Mr. Chair, in that we said...
When I asked you about the inherent rights of the parents are God-given, and you concluded and you said yes. So I'm just a little bit, now you're...
No, Mr. Chair, can you let me tell what I said? I said that in those cases,
1 minute, please.
The court should still focus on the best interests of the children. That's what I said. I also said that I believe that parents are responsible for their children, that they bear a responsibility toward their children to act in their children's best interest. In this, right now the law says that the court in deciding these cases looks at the best interest. So put yourself in the shoes of a judge and think, if you had a standard that said, do what's in the children's best interest, could you come to a fair result in a case? Now some people are saying, no, if we were judges, told to look at the best interest of the children, we would do something horrendous to, I guess, fathers or mothers. The bill is, the current law is gender neutral. But you're saying the law telling you to look out for the best interest of the children would prevent you from coming to a fair result. That somehow or another you would be unable to come to a fair result for those children. I don't think so. I think that in most cases, parents using this structure are able to come to agreement, which is what we want. When it does go to court,
Okay, I'd like to stop you right there, Ken, because in House Bill 5701 by Representative Molinar, the Parenthood Plan, is the family law section in favor of this? Well, that's before the family preservation. It's before the Senate right now.
I'm sorry, I don't have the bill in front of me, but I can review it if you want.
Yeah, but it's about both parents coming before, no litigation, make an agreement, and the judge finalizing on that.
I don't have the bill in front of me, so...
But to my mind, do you think that would be the best, so they wouldn't have to go to litigation to arrive at a decision?
Mr. Chair, I would have to look at the bill.
No, let me ask you in context, not apart from the bill.
You think it's a good idea for parents to agree? Yes, that's what I do for a living. I help parents
before litigation, before a lawyer, if they come before an agreement, before a judge, would that be good?
Mr. Chair, that's what I do for a living. I believe that that's the best way for parents to work things out. Yes.
Very good.
Thank you.
Thank you very much.